Hello. Thank you so much, everyone, for joining us today for the Center for Security, Race, and Rights at Rutgers Law School's event expert discussion on abortion, religion, and race in post-Roe America. My name is Sahar Aziz. I am a law professor and Chancellor Social Justice Scholar at Rutgers Law School. I'm also the founding director of the Center for Security, Race, and Rights. And I'm delighted today to moderate as well as participate in this very important and timely topic alongside two remarkable and brilliant legal scholars, Asifa Quraishi-Landes and Cynthia Soohoo, which I will introduce shortly. While we wait for more people to log on, I will just put a plug in for the Center for Security, Race, and Rights, and encourage you to visit our website at csrr.rutgers.edu, as well as follow us on social media at RUCSRR on Twitter and Facebook, and Rutgers CSRR on Instagram. The Center for Security, Race, and Rights is the first and only center at a U.S. law school that focuses primarily on the civil and human rights of Muslim, Arab, and South Asian communities through a cross-racial and interfaith approach. And today's lecture on abortion, religion, and race is intended to look at abortion rights through this cross-racial and interfaith perspective. And so what we'll talk about today is the doctrinal analysis, which is what Professor Soohoo is going to focus on, and then the role of religion in lawmaking, and particularly perhaps comparative perspective, or looking at Islamic law perspective, because some of you may have noticed in the media that there have been some pejorative comparisons to the American Taliban and to Sharia law, which triggers all sorts of other problems in terms of why Sharia law is even coming up when we're talking about U.S. constitutional law. But Professor Quraishi-Landes is going to address some of those issues as well as the role of religion in general. And then I will talk about the racially disproportionate impact of this Dobbs decision and the overruling of Roe, with a particular focus on the adverse impact on African-American women. So before we get started, I have the distinct pleasure of introducing my two co-panelists. And the first I will introduce Professor Soohoo, Cynthia Soohoo, who is a professor of law and co-director of the Human Rights and Gender Justice Clinic, formerly named the International Women's Human Rights Clinic, at the City University of New York School of Law. She is an expert on reproductive rights and women's human rights and human rights advocacy in the United States. She supervises the clinic's work on reproductive rights and health, trafficking, and youth in the adult criminal justice system. Prior to coming to CUNY, Professor Soohoo was the director of the U.S. legal program at the Center for Reproductive Rights. In addition to managing U.S. litigation and state advocacy, she spearheaded and supervised the development of the center's U.S. human rights advocacy and fact-finding work and the growth of its law school initiative. Professor Soohoo is an author and frequent commentator on women's human rights, the rights of youth in detention, and human rights advocacy in the United States. She has authored submissions to the U.S. Supreme Court, appellate courts, and international forums on access to abortion, forced sterilization, and criminalization of reproductive choices. She's also co-edited Bringing Human Rights Home, a 3-volume book on human rights in the United States, which received the 2008 Gustavus Myers Outstanding Book Award. And she's a co-editor with Professor Richard Starrow of the Reproductive Rights Professor blog and frequent contributor to the Bringing Human Rights Home Law Professor blog, excuse me. And we also have the distinguished Professor Asifa Quraishi-Landes, who specializes in comparative Islamic and U.S. constitutional law with a current focus on modern Islamic constitutional theory. She is a professor at Wisconsin Law School, and she is a 2009 Carnegie Scholar and 2012 Guggenheim Fellow. Her recent publications include Healing a Wounded Islamic Constitutionalism, Sharia, Legal Pluralism, and Unlearning the Nation-State Paradigm, which is forthcoming in Transformative Constitutionalism, the book. And she's also the author of the article Legislating Morality and Other Illusions about Islamic Government, that's also forthcoming in another book. She's currently working on a book manuscript tentatively titled 3 Pillars Constitutionalism, in which Professor Quraishi-Landes proposes a new model of Islamic constitutionalism for today's Muslim majority countries. Professor Quraishi-Landes holds a doctorate from Harvard's Law School and other degrees from Columbia Law School, the University of California, Davis, and the University of California, Berkeley. And she has served as a law clerk in the United States Court of Appeals for the Ninth Circuit. And so we are extremely fortunate today to have these two legal scholars with us to educate us about these various complications or the various legal, political, and social implications of the Dobbs decision that just came down last week from the US Supreme Court. So without further ado, I'm going to cede the virtual platform to Professor Soohoo, who I believe will be using a PowerPoint. And just to give you the run of the show, each speaker is going to speak between 12 to 15 minutes, and then we're going to open up the Q&A. And you can use the Q&A function to ask your questions, at which point we'll be moderating. And we do hope to have a lively discussion because this is a very important and rightfully controversial issue that warrants all of us to be zealously engaged. So with that, Professor Soohoo, the floor is yours.
Thanks so much, Sahar, and thank you, and thanks to the Center for organizing this panel and inviting me to participate. I'm gonna try and share my screen. Okay, can people see screen? Okay. All right, so what I'm gonna try and do right now is to provide some background to ground our discussion. I'm gonna do background on Roe and Casey, so we kind of know what the law used to be, discuss the shift on the Supreme Court. Then we'll actually talk about what the Dobbs decision actually says. And then I'll talk a little bit about the post-Dobbs landscape. So I think for the last several weeks, we've all been mourning the overturning of Roe versus Wade, and rightfully so. But I think it's important for us to recognize why Roe is a critically important Supreme Court case, and what it did and what it did do and what it didn't do. Roe and Casey recognized a constitutional right to abortion, but as emphasized by reproductive justice activists and communities of color, the legal right to abortion was just a floor. It's never been enough to ensure that all people have had the means to actually access abortion services. And so even while Roe and Casey were the law of the land, Congress and states were allowed to adopt measures making it difficult, or in some cases impossible, for people to actually access abortion services. And that includes bans on coverage of abortion in Medicaid, imposing waiting periods and regulations that forced clinics to close, even as abortion remained legal in the United States. These barriers, ones that the state ignored, exploited, or created, disproportionately impacted poor people, rural people, and people of color. And so I think that's important for us to recognize as we talk about what Roe means and what it doesn't mean. That said, I think that while the constitutional right to abortion has never been enough, it has provided a critical floor, a legal right that blocks states from making abortion illegal and forcing people to bear and give birth to children against their will. So what did Roe and Casey actually say? The top line is Roe and Casey recognized that while the state may have an interest in protecting prenatal life, pregnant people have rights. And so Casey recognized that the Fourth Amendment protection for liberty includes and protects the right to decide whether or not to bear a child. And I think this was, and Casey recognized, despite the fact that a long history in the United States of women occupying inferior status, the Constitution, at least in 1992, a recognition that the Constitution must protect all individuals, male or female, from the abuse of governmental power or unjustified state interference, and that protected liberty for a body that has a uterus includes the ability to decide whether or not to bear a child. On the other side of the equation, Roe rejected an argument made by the state of Texas that unborn people are persons with rights protected by the Constitution. Roe recognized that while states may have a legitimate interest in protecting the life of a fetus that may become a child, states can't adopt one theory of life to override the rights of a pregnant person. And so even as Planned Parenthood versus Casey slightly restated Roe the standard under Roe, it really reaffirmed the basic holding in Roe versus Wade, that a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy before viability. And so even as Casey opened the door for states to regulate abortion a little bit more, as long as those regulations didn't impose an undue burden on a person's right to elect an abortion, the bottom line remained that the state cannot ban abortions prior to viability. And this has been the law since Roe in 1973 and continued to be the law. The lower courts routinely applied that standard and really didn't have a difficulty in applying that standard. That is until the changes that we saw in the Supreme Court. So as late as 2016, when Justice Ginsburg and Kennedy were still in the court actually issued a decision, Whole Women's Health versus Hellerstedt, that reaffirmed Roe versus Casey. But as we saw the changes to the Supreme Court's personnel, its abortion jurisprudence became unsettled. Suddenly, states started passing laws that were clearly unconstitutional, including bans on abortion. And in 2018, Mississippi passed a ban on abortion at 15 weeks, which was the law that was at issue in Dobbs versus Jackson. And in 2019 and through 2020, states started even going further, passing bans on abortion at 6 to 8 weeks. And 3 states actually passed laws that banned abortion at conception. And Mississippi initially, in 2018, I think, or 2019, Mississippi initially asked the court to take the case to consider whether its 15-week ban was unconstitutional. But it didn't actually ask the court to overturn Roe versus Wade. But by the time the case actually made its way up to briefing and the shifts on the court's personnel became clear, Mississippi asked the court to consider overturning Roe versus Wade. And I think this is really critical for us to understand as we think about the Dobbs decision and think about the reasoning, as the dissent emphasized, that, despite sort of the arguments that are made in Alito's decision, as the dissent said, the court reverses course today for one reason and one reason only, because the composition of the court has changed. Okay, so so we're going to move on to the Dobbs decision. The Dobbs decision was a 5-1-3 decision. 5 justices signed on to Justice Alito's majority opinion. These are the 4 justices. Thomas, Gorsuch, and Kavanaugh. Those are the 5 conservative justices, except for Justice Roberts. Justice Thomas filed a concurrence as well. Justice Kavanaugh filed a concurrence, and Justice Roberts filed a separate concurrence, concurring in judgment, but not in the reasoning of Justice Alito's opinion. Justice Roberts said that he would uphold the 15-week ban, but not overrule Roe and Casey. And then there was a joint dissent that was filed by Justices Breyer, Kagan, and Sotomayor. So here's the top line of Justice Alito's majority decision. Justice Alito holds that despite the last 49 years, the Supreme Court got it wrong, and the Constitution actually does not protect the right to abortion. Justice Alito would apply a rational relation test to any state abortion law because under his analysis, there is no constitutional right to abortion. Justice Alito's decision is sort of marked by a cramped reading of what liberty is protected by the Constitution. He says he would look at whether or not the right is deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. And we'll talk about that in a minute. Also, he says that stare decisis is not an inexorable command, and the court can overrule cases that are egregiously wrong. And it seems like egregiously wrong might be any case that the conservative majority is opposed to. Okay, so Dobbs really resets the constitutional balance, and now it's pregnant people don't have abortion rights, and states can impose its beliefs on their bodies. And in order to get to this conclusion, Justice Alito looks at history and tradition to determine whether abortion should be constitutionally protected. And in doing so, he really relies on state laws that made abortion illegal in 1868 when the 14th Amendment was ratified. And the decision is really notable because it really doesn't acknowledge at all the real invasion on the bodies and lives of pregnant people when the state imposes forced pregnancy. So no constitutional rights to abortion for pregnant people. What about the rights of the state to impose its views about prenatal life? The decision says that it's not based on any view about if and when prenatal life is entitled to any of the rights enjoyed after birth. But I think if you look closely at Alito's decision, sort of inherent in a lot of his reasoning, it really seems to adopt a moral position about the status of the fetus. He tries to say that abortion is different than other constitutionally protected rights relating to intimate decision-making because it's a critical moral question, and that it's different than other cases because, as the state says, it destroys an unborn human being. So I think, like, while he's trying to say that the decision doesn't take a position about the value and the status of fetal life, in fact, I think in order to make these statements, it really is. But the other important thing to know about the decision is that it really opens the door to the state imposing its views about the value of prenatal life on pregnant people. So just briefly, some critiques of Alito's history and tradition test for whether or not a liberty right is protected by the Constitution. This backward-looking test really, no surprise, right, privileges the rights of white cisgender Christian men because we're looking back to the founding of the country or 1868. And it really focuses on a past when others were not recognized as full citizens and women didn't even have the right to vote. I'll mention here, but there's not really time to go into it, but I think his interpretation of the historical record is problematic. I think there are also arguments that when we're thinking about the meaning of the Reconstruction Amendments, which were drafted after the Civil War, if we're actually thinking about what was the intent of Congress when the Reconstruction Amendments, the 13th and 14th Amendments were ratified, the record really indicates an intent to address reproductive autonomy issues like forced pregnancy and childbearing, as Congress talked about trying to ameliorate and end the condition of slavery. I think that we should note that the test also threatens precedents around the court's precedents around intimate private decisions like contraception, sexual relations, and marriage. And that's because these rights really were not recognized in 1868 as well. So just a quick note about the concurring opinions. Chief Justice Roberts, I think, is really, while he says he would not have overturned Roe versus Wade, and Casey, I think he's really playing the long game. And in some ways, I think he was just angry that the other 5 justices didn't play along. He said he would have upheld the 15-week ban and only still recognize that people have a right to abortion, but that right would only require a reasonable opportunity to choose. That's kind of a standard that I think would have been difficult or impossible to actually implement. But tellingly, he said he would have left for another day whether to reject any right to abortion at all. So I think Roberts really wanted to chip away at the abortion right rather than overturn Roe versus Wade immediately because of backlash on the court. But still, I think we need to keep in mind that for Roberts, it was more of a long-term game. Thomas, I think his decision, his concurring opinion, is notable for really calling a spade a spade. Justice Alito goes to great lengths saying that Dobbs really only impacts abortion and it's not going to affect other rights like the right to contraception or the right to intimate sexual relations or gay marriage. But Thomas actually says that the Supreme Court should eliminate all of its substantive due process jurisprudence. And he especially invites the court to reconsider Griswold, Lawrence, and Obergefell. Kavanaugh, I think his opinion, I think it's just a gaslighting opinion. He tries to say that the Constitution doesn't protect abortion, but that it's neutral and that there are two sides on the abortion debate that should have equal value, and we should let elective representatives decide through the democratic process. But I think here he's really abdicating one of the important roles, the important role of the Supreme Court, and why we have fundamental and constitutional rights, right? We don't actually all get to vote on what happens to one person's body. So implications, I think that there's, again, the line of cases protecting private intimate decisions around contraception, sexual relation, and marriage are at risk. Justice Thomas invites these challenges, and the decision really gives the states enormous power to protect and recognize the rights for prenatal life without any constitutional limitations. And so that means that whether or not abortion is going to be legal will depend on the state where you live. And states can criminalize, that means that states can also criminalize people who provide and have abortions, and that the state can define protected life to begin at conception, right? And so that includes abortion bans from conception, but really laws that ban or that protect zygotes, embryos, in addition to fetuses, which I think is going to have implications for contraception and IVF. So where are we now? So as I said, it's really up to the states, and I think it's kind of chaos out there, and really I just horrifying in terms of what's happening to people on the ground, right? People who actually did not want to be or pregnant and don't want to be pregnant are trying to make decisions and act in a short period of time, right? Like having to deal with all of this uncertainty. Estimates are that about abortion will be banned in about half the states, and that's because there are old pre-Roe laws on the books in many states that now can go back into effect. Many states have passed bans on abortion in the past that have been enjoined, and right now the states are going back into courts to try to get those injunctions lifted, and states have also passed trigger laws. So you can see on this map on the left, I think 9 states actually currently have bans in effect. Bans are expected soon in other states as they satisfy the requirements for their trigger laws, or sometimes it has to be a number of days before their trigger laws go into effect. The other thing that's happening is that there's actually active litigation. A lot of cases have been filed arguing mostly in state court, arguing that state constitutions protect the right to abortion in these states. There's also been a lot of challenges arguing that these statutes are vague. A lot of, like in states like Louisiana, states have passed multiple abortion bans, overlapping bans that are often inconsistent. And so actually Louisiana's trigger laws and anti-abortion laws have been stayed because they're vague. On the left, you see that there are other states where abortion will not be banned at conception, but will be banned very early in pregnancy. In some states at 6 weeks, in some states 15 weeks. There are other states where abortion is legal for now, but there's sort of the understanding that the states probably will pass laws banning abortion soon. So for instance, in Indiana, the governor actually called for a special legislative session to try to get the legislature to take up new anti-abortion restrictions. And then we have the abortion-friendly states. These states have actually taken action to protect abortion rights, sometimes by codifying the abortion right either in state law or by, in some cases, trying to take up constitutional amendments. States have also been doing things like trying to expand provider capacity. So in New York, our governor actually allocated money to abortion providers to make sure that they can actually expand capacity, anticipating that there are going to be many more people coming to New York. And also some states have made money available for people who are coming to their states from other states to pay for abortion procedures and to pay for their expenses. States like New York, Connecticut, and California have passed laws actually protecting abortion providers and protecting patients from harassing lawsuits if they see patients from other states. And so these laws say that California and New York are not going to provide information for litigation from out of state, and won't comply with subpoenas, won't comply with extradition requests. And New York and I think New York and Connecticut have passed laws creating a reverse cause of action, which is called unlawful interference with rights, which would allow a New York abortion provider who was sued for providing services that are legal in New York to countersue, which I think is a great idea. I think that lawsuit actually provides triple damages. The other thing to know is that cities are getting into the fray. So Austin, Atlanta, and Tucson, in those cities, the cities have passed resolutions saying that no city fund should be used to track who has abortions, and that the police should deprioritize investigating people who have abortions. And a lot of prosecutors have also said that they're not going to prosecute. So I think this sort of new Wild West has really opened up opportunities for government officials at all levels to either try to impose anti-abortion restrictions, or really to try to minimize their impact. With that, I'm going to stop and turn it over to my colleagues.
Thank you, Professor Soohoo. That was perfect. Nice, succinct summary of the key issues and the key arguments. So we'll next go to Professor Asifa Quraishi-Landes, who will address examinations of these issues through Islamic law, as well as other issues that relate to religion or religious freedom. So the floor is yours, Professor Quraishi-Landes.
Thank you. And thanks for the invitation. It's really wonderful to be here with my friend Sahar and to meet a new friend. So as Professor Aziz said, I come to this topic with two areas of expertise, constitutional law and Islamic law. So I'm going to start with just a few words about the nature of American secularism, which some people usually shorthand as the separation of church and state. That phrase is not actually in the Constitution. What is in the Constitution is, in the First Amendment, we have what we call an establishment clause and a free exercise clause. So the establishment clause says that no state can establish a religion. So that's familiar to us. That's not having any state impose or declare that there is one religion for the state or for the country, so that people who don't belong to that religion are not welcome, or that they are, that they must be forced to believe differently. So that's a strong position. It gets a little complicated around the edges. You may have heard of some cases where, what about state funding that goes to private religious schools? There's lots of Supreme Court case law on that. And the latest one is, what about a post-game prayer by a coach on a school campus? What does that do? Is that entangling the state with religion? So this is a whole area of constitutional law that's quite interesting, but that's around the edges. The basic concept is that the state can't establish a religion for the country and for the state. The second clause that's important is the free exercise clause, which is that everyone here is free to exercise their religion, their spiritual beliefs, however they want to, as long as it doesn't interfere with general law of the land, public policy kinds of things, which again gets complicated around the edges. I mean, some of the simpler ones are like, you can get an accommodation for not having to take an exam on your Sabbath. Let's say your Sabbath is Saturday and they're holding the SATs on Saturday, or for Muslims getting suhoor accommodations in the school dorms. These kinds of things are pretty well established. Again, it gets complicated around the edges. What about a religious exemption to a vaccine mandate in places where it's government control, like military service persons, or working in a hospital? You might have heard of cases where a city employee didn't want to give a marriage license to a same-sex couple because of their religious beliefs. So again, a lot of case law has to wrestle with these kinds of things. So that's the landscape of religion and the Constitution, very, very generally broad brush. That's my constitutional law hat. So my Islamic law hat, you might be expecting me to answer the question that's all over the place, which is, what does Islamic law say about abortion? So I'm going to actually back up even before that to say that there is a constitutional structural question that I think people are missing. And it actually goes to something quite similar to what we see in the First Amendment. It's not a separation of church and state or mosque and state, but it is a separation of types of law that is an established Muslim tradition going all the way to the beginning of Muslim societies, pretty much until the modern period. There's a lot of transformation at the colonial time period, but the vast swath of Muslim history, you see a separation of types of law, not of religion and state, but of types of law. The types of law, one of them is called fiqh, which means the interpretation or understanding of Sharia. So that's based on scriptural interpretation of religious scholars. They give us rules on how to live my life as a Muslim, what I eat, how I dress, who I marry, who I leave my money to, how to pray, these kinds of things. This is how I live my life as a Muslim. Siyasa is the word that's used to refer to the other kind of law. And the other kind of law is the law that the state or the sultan or the ruler is using the police power of the state to impose particular life behaviors on people. And that, very importantly, is not scripturally based. It's based on something very different. And that is the principle of serving the public good. In Arabic is maslaha amma. So the sultan was actually specifically, they resisted sultans and rulers from telling us which interpretation of Islamic practices was appropriate, and was very strongly limited to the kinds of rules that keep public order, keep us safe. We would say today things like zoning laws and health regulations and traffic laws and those kinds of things. So keep the laws that you need the state to do something, but it's not a matter of scriptural interpretation to figure out what to do. It's just identifying what's going to serve us well. All right. So when people ask the question, what's going on here with these kinds of abortion laws, I think what we need to be is very clear on what are we asking. So are we asking, what does Islam tell me to do? That's a very different question than what should the state do when it's using its police power on everyone. So I don't eat pork, but do I think the state should punish people for eating pork in the United States? The answer to that question has to be on the category of siyasa, which is what serves the public good. So I don't think it serves the public good to punish people from eating pork, even though I choose myself not to eat pork based on my own scriptural understanding. So when people see saying, what does Islam say about abortion? I want us to realize that question is missing a step. What does Islam say Muslims should do on the topic of abortion is a very different question than what does Islam say about state control on the topic of abortion. So like I said, there's a long history of scholars and Muslims resisting the state telling us which interpretation of scripture to follow. In fact, Islamic law, Sharia interpretation, the whole world of fiqh, the first category I gave you, is made up of multiple interpretations on almost every question about how to live life as a Muslim. So if somebody tells you the Sharia says this, you probably should be quite suspicious, because usually there's more than one interpretation. And this way, we're quite similar to Jewish law, from what I understand. So multiple different interpretations of scripture. All of them did this with the understanding that they were human beings and they were fallible. So therefore, their answers were really good answers, but they could be wrong. And so therefore, you could choose a different interpretation. So that's how you get all these different schools of law. So Muslims would recognize Shafi, Hanafi, Jafari. These are some of the schools that you follow. There were hundreds in the past. They're shaken down to about 5 today. So when you look at all those schools on the question of how should Muslims address the question of, should I have an abortion? Can I have an abortion? You'll actually find a whole variety of interpretations all across those schools. The difference boils down to a difference of interpretation of when the soul is breathed into the fetus. So the Quran actually is quite specific about, it's actually interestingly very specific about the evolution of the fetus in the body, in the uterus. And at some point in that time period, there is reference to the soul being breathed in to the fetus. And so before that time, it's not considered a life in the sense of murder. It's not a soulful life that you would be killing, a life that's going to be judged in heaven someday, right? So what are the ranges of interpretation? Well, the soul being breathed in, and what is that? Is that the marker for when you're not killing someone? The majority seems to be 120 days after conception. They go backwards from there to 80, some say 40, and the minority position says at the time of conception. So if you're a Muslim, you can choose which of those interpretations you want to follow, and all of them are equally valid. Even though they disagree with each other, we're used to that. We do that all the time. Disagree with each other, but they're all still equally valid. By the way, abortion to save the life of the mother at any time in the pregnancy is unanimous across all the schools. All right, so what should you do depends a lot on your specific circumstances, and the scholars address lots of different circumstances that might be relevant in an individual choosing to decide this, and that with their own spiritual advisor and family considerations, what kinds of things would be relevant to this. So Islamic law has a lot of range of, it's not just prohibited and allowed, but there's ranges of like recommended, discouraged, neutral. So depending on your particular circumstances, you might find your spiritual advisor giving you different answers to the question of should I or can I have an abortion. Some of the considerations they look at are the nature of the hardship of life for the fetus or the parents after if they were to be born. They address the question of rape and incest. Health of the mother is a big one too. So in other words, no one size fits all on these cases. There's a lot of consultation that is necessary and happens, again, with spiritual consultation with your spiritual advisor, your medical advisor, your family. And that is all the more reason for the state not to do a one size fits all ban, because it doesn't allow for all the nuance that all the Muslim schools actually did specifically accommodate a lot of nuance that's allowing for the particular situation. So if the state picks one of those views, that would restrict the choice of Muslims choosing across those schools. And especially if the state happens to pick the most restrictive view, that let's say it picks the minority view of it's not allowed after conception, well, then all the other schools are now restricted. I no longer have what I call my Islamic religious freedom to choose among the different schools of Islamic law to live my life. So you're restricting my freedom of choice in my own religious choice. The only reason from a Sharia perspective that a state should restrict those kinds of choices, if, going back to my earlier point, it serves the public good. So that's the question I wish we would be talking about. If you're motivated by your own religious beliefs about when life begins, that's fine. We disagree on that. I don't actually believe life begins before the soul is breathed in. So we're going to disagree. And actually the Roe case talked about how this is a profound moral philosophical debate upon which there's no consensus across humanity on when life begins. So the state can't just pick one of these views based on it says one of these views about when life begins is more correct. From a Muslim perspective, it could choose one of those views based on if it serves the public good to choose one of those views. So that's the question I wish we were talking about. Muslims and non-Muslims talking about this, not just what does Islam say I should do if I was pregnant, but rather what is in the public good for the state to control here right now in the United States. That's, to my mind, that's an Islamic question about what the government should do. So the government's responsibility from a Muslim perspective is to serve the public good. And then when I look at that, I look at a lot of harm from these bans that we just heard from Professor Soohoo that are in progress and may even more come. I see documentation of the likelihood of more maternal and fetal death. I see the likelihood of a lot more unwanted children overburdening an already overwhelmed foster care system. I see families falling below the poverty line if they're not already there, homeless because they have no financial ability to raise children. Maybe they have several children already. The loss of jobs. Many of these children are going to have special needs that might have been aborted otherwise, but now they are, needing extra care, and many places do not have sufficient support services for these children. So the parents may lose their jobs to stay home with them. We have terrible parental leave policies to help these families care for these children. There is lack of adequate healthcare support, both prenatal and pediatric. There is, as we just heard from Professor Soohoo, there's a disproportionate impact on the marginalized in our society, racial minorities, poor, undocumented immigrants, etc. And against all that harm, when I'm trying to see what's the public good, on the other side, I see what we heard in the court, the potential in saving, the belief in saving potential life. But that life is a life that many of us disagree about when that actually starts. So if you had a thought experiment of another question about when life begins, let's say you belong to a religious community that believes all animal life is sacred, and that includes insect life. So if you look at Hindu beliefs and Jain beliefs, to my knowledge, what if the state were to ban all killing of cattle or even killing insects? I think when you think about that, you realize how it does feel really restrictive for the state to pick one view of when life is and what life is, and then impose it on the rest of us. So I say, and many others are saying, it is in the best interest of the public good, including the public good of religious diversity, for the state to stay out of this altogether, and these decisions should be made by the individual with their medical and spiritual advisors. That's it. Thank you. Over to you, Professor Aziz.
Thank you. Thank you, Professor Quraishi-Landes. That was informative and provocative at the same time. I have no doubt that there will be a lot of people who want to ask questions, and I'll just remind the audience that we do have a Q&A function. So please feel free to ask your questions now, and we'll be ready to moderate soon. Okay, so let me just quickly get to my PowerPoint.
Told you multitasking was a bad idea. There you go. Okay, you got it?
Yes, I do. I have it. Okay. Let's see. I just have to share my screen. All right. All right. Can you all see my PowerPoint?
Yes, we can.
Great. Okay. So what I want to focus on today is really looking at the racial disparities and the disproportionate harm on minority women, and particularly Black women, because of the continued legacies of slavery. And also, oftentimes what we see is that Black women tend to get to be the most disproportionately harmed when we see these types of laws, whether it's related to healthcare, whether it's related to other types of individual rights and government functions. So I'll talk first about the history of controlling Black women's reproductive functions, race and abortion access, race, abortion, and maternal health, and the intersection of poverty, race, and the absence of healthcare. So first, let's just be very clear, and I want to reiterate what Professor Soohoo mentioned, is this reference, right, that the court makes, the majority opinion makes throughout in terms of how to define fundamental rights as being ordered liberty that is deeply rooted in the nation's history and tradition. So that starting point is highly problematic. And I realize that that means that from a doctrinal perspective, things, this requires some change, but we have to at least accept that the nation's history and tradition is rooted in European settler colonialism that almost eliminated Native Americans. It was effectively an attempted genocide and coercive assimilationism. It's rooted in the enslavement of Africans, and it's also rooted in treating women as property. And I'll also add to that kind of a history of xenophobia, where new immigrants in particular are often mistreated, discriminated against, and presumed guilty and suspicious. So we need to be very weary of this reliance on the nation's history and tradition when we're examining constitutional law, and especially when we're looking at fundamental rights. Okay, so let's just, this is a very quick recap, as I only have a few 10 to 15 minutes, but let's be clear that the history is that the state has always wanted to control Black women's reproductive functions, and it goes all the way back to slavery, right, where Black women were denied all bodily autonomy, and the law expressly endorsed the notion that they lacked humanity and could be bred for their owner's profit. And when Black women became pregnant because of sexual violence or otherwise, the law regarded them as merely breeding animals who had no claim to their children. And if you, just as an example, there was a statute in Virginia colony in 1662, right before the US became independent, and made all children of enslaved women the property of their masters by operation of law. And similarly, a South Carolina court, in an opinion typical of the time, later declared that the young of slaves stand on the same footing as animals. So we can't dismiss that history if we're going to talk about the history of the nation. And ultimately, the denial of reproductive freedom for Black women continued even after emancipation, when Black women were subject to pervasive sexual violence and forced sterilization, which I'll get into in a minute. So for those of you who have studied the 20th century, you'll be familiar, the early 20th century in particular, be familiar with the era of eugenics, which brought invasive and permanent compulsory surgical sterilization, which had a disproportionate impact on poor women and racial minorities. And so, for example, Indiana passed the nation's first law requiring the sterilization of the so-called mentally unfit in 1907. And by 1935, 27 states mandated sterilization of the feeble-minded, those on welfare, and those with genetic defects. Now, while it wasn't only Black women or brown women or racial minorities that were affected, there were also people from Southern Europe and Eastern Europe who were Jewish or Catholic, and most certainly poor women. But again, this is part of our nation's history that is quite sexist and racist. And as a result, right, the people who were in fact overrepresented in the ranks of women who were forcibly sterilized, of the 8,000 that were considered mentally disabled persons that were sterilized by the North Carolina Eugenic Commission in the 1930s, 5,000 were Black. So that's more than 50 to 60% or more than 50%. By 1983, when Black people represented just 12% of the population, 43% of the women sterilized in federally funded programs were Black. And then finally, it's estimated that between 100,000 and 150,000 Black women have been sterilized by government-backed programs using federal funds. Forced sterilization became so common, for example, in Mississippi, which is where the Dobbs opinion originated. It was the Mississippi law that sought to prohibit abortion after 15 weeks, that Fannie Lou Mae, the famous civil rights, Black African-American civil rights advocate, and the founder of the Mississippi Democratic Party, reported that by 1965, 60% of Black women in Sunflower County, Mississippi, had been sterilized without their consent, so much so that it had a name. It was called the Mississippi appendectomy. Meanwhile, if you kind of go forward after, whether it's before Roe, but most certainly after Roe v. Wade, the data shows that Black women do seek abortions at higher rates, and partly because of lower contraceptive access, and partly because their pregnancies are more likely to have more dangerous complications. However, Black women also disproportionately live in states that will ban abortion. And so this is another future disproportionate harm of the Dobbs decision. And in the Deep South, such as states as Mississippi, they only have one abortion clinic. So this has been something that's been going on for decades now, post-Roe, yet Black people account for over 37% of the state's population. And then finally, according to 2019 data from the Center for Disease Control and Prevention, US Black women are 5 times more likely to have abortions than white women, while Latina women are twice as likely. And so the reason that matters is just to show the disparate impact that if abortion is in fact prohibited in places where African-American women reside, they are going to be disproportionately affected in terms of not having that choice and that access. Let's look at 2 other places. Oklahoma, for example, signed a 6-week abortion ban. This was in 2019, which is the nation's strictest. This is pre-Dobbs. And the abortion ratio for Black women in Oklahoma was highest at 179.5 abortions per 1,000 live births compared with other women. And yet Black people accounted for only 7.8% of the population. In Mississippi, nearly 40% of the population is Black. 84 and nearly 20% of the women in the state live below the poverty line compared to 12% nationally. So again, it's no surprise that the state's dismal health outcomes are disproportionately borne by Black women. Now let's talk a little bit about maternal health, because that's also very important when we're talking about abortions. We have some questions about that, but it's approximately, from 2013 to 2016, Mississippi reported a pregnancy-related mortality ratio for Black women of 51.9 deaths per 100,000 live births. And that's 3 times higher than that of white women in the state who reported to have a pregnancy-related mortality ratio of 17.3 deaths per 100 live births. And again, I'm highlighting Mississippi because this was the case, that this was the statute in the state in which the statute was at issue in Dobbs, which ultimately obviously has now a national implication. Cardiovascular conditions and hypertension disorders were the most common cause of pregnancy-related deaths in Mississippi, both of which Black women experience at much higher rates than white women. And again, this would affect decisions as to whether a woman would choose to have an abortion. A recent study shows that banning abortions nationwide would result in a 21% increase in the number of pregnancy-related deaths overall, and a 33% increase among Black women. Now let's talk about pregnancy-related deaths. So while maternal mortality has increased among all races of US women over the past 20 years, which in itself is problematic and raises a lot of healthcare and health-related issues, Black women are 3 times more likely to die from a pregnancy-related cause than their white counterparts. Again, so if you don't have access to abortion, that risk is magnified. And even when Black and white women have similar incomes, similar prenatal care, and other indicators, Black women have a higher risk of pregnancy-related death. And although that's not within the purview of the Supreme Court, it's something we have to consider when abortion becomes unlawful. An ectopic pregnancy, which is when the egg implants outside the uterus and cannot come to term, but its growth threatens a woman's life, these pregnancies are the 5th leading cause of maternal death for Black women. And a 2014 study shows that among Medicaid recipients, rates of ectopic pregnancy are higher in Black reproductive women than other women. And another study found that between 2014 and 2017, that denying all wanted induced abortions in the US would increase pregnancy-related deaths by 7% in the first year and 21% in subsequent years. And for African-American women, it would produce a 12% increase in deaths the first year and a 33% increase in the following year. So obviously now that it's prohibited, or I should say now that the states can prohibit abortion, this data can be tested. Now, when you look at the intersection of race and class, and particularly race and poverty, the numbers become even more startling because of systemic racism that we have in the way that wealth is distributed, the way that income is distributed, the way that opportunity and education is distributed along racial lines, even if unintentionally, but certainly that's what the disparate impact is. So nearly 40% of the population of Mississippi is Black, and nearly 20% of the women in the state live below the poverty line compared to 12% nationally. So again, another reason why you have disproportionately harmful health effects on Black women. In 2014, 3/4 of abortion patients were low income, with 43% living at less than the federal poverty line. So this is independent of race, although as we see with much of the data, a disproportionate number of Black and brown women are among the low income. But the poorer you are, right, the more that you choose to have an abortion, at least as of 2014, and I suspect the numbers probably have gone up. 1/3 of the Black population in Mississippi lives below the poverty line. And for Black women alone, this number jumps to 36%. And Black women in Mississippi make only 52 cents per dollar that a man makes. Okay, so just quickly as I end, I just wanted to bring up some maps which Professor Soohoo had mentioned, had brought as well, but I want to reiterate. This is from kff.org. This is actually an interactive map. This is just a screenshot that shows the reported number of legal abortions by state. And so you can see where, the darker the color, the more there are abortions. Now, granted, you have to keep in mind the percentage, the population size, which Texas is a large state, Florida is a large state. And then these are the states that have trigger laws that are effectively, if not now, or at least within 30 days of after the Dobbs decision, abortion will now become unlawful in those states. And it's predicted that 26 states are certain or likely to ban abortion. So we are talking about half the country. And then finally, I just wanted to bring this up to show that this decision to allow states to ban abortion at least is wildly unpopular in terms of what the population, in the United States believes that people should have the right to choose whether to have an abortion. And obviously we see a big disparity between Democrats and Republicans. But the Supreme Court has truly regressed the country back 50 years, not only doctrinally and through, in terms of constitutional jurisprudence, but it's also regressed us back socially and in terms of where the public is at this point in time, which is why I think Roberts ended up concurring instead of joining the majority, because the legitimacy of the court is certainly in very serious in jeopardy at this point in time. Okay, all right. So I think we've given the audience much food for thought. And I'll now moderate I'm gonna put this on gallery mode, okay? And I'll moderate the Q&A. Okay, so let's start with, Dr. Quraishi-Landes. Is restricting the choice of selection of abortion viewpoint based on your school of fiqh worse or better in terms of public good than preventing abortions that may be deemed un-Islamic by the majority of schools? Or how is that even evaluated?
I'm trying to understand the question. Is restricting your selection worse than preventing those that are deemed un-Islamic by the majority of schools? I mean, it really is my Islamic constitutionalism voice that's speaking here. Is it the role of the state to impose the majority opinion of all the Muslim schools on everybody who disagrees with that. Classically speaking, generally, no. That's why you still could pick a minority opinion, because the state didn't make it impossible for you to pick one. So is it in the public good if there is a majority opinion that is, you could make an argument that, so for example, on another, well, I'm not going to get too complicated, but if you can make the argument that a majority opinion or even a minority opinion is in the general public good, then go ahead, make that case. And then you're making it the state law, not because it's the majority opinion, you're making that law because it serves the public good. That's why I went into all the harms, and then Professor Aziz just went through a bunch more. So the conversation we should be having for the state law should be about what serves everybody the best. And of course, we're going to disagree about that, but at least let's talk about that, not talk about what the majority opinion is. Majority opinion isn't even dispositive for an individual Muslim. An individual Muslim can still pick a minority opinion. And so the majority opinion might be persuasive for you as an individual, but that is not the question that the Sultan should be asking when they're looking around to see what should I do to make everybody safe. And so in our situation, the law of the land is made by a democracy, not by a Sultan. So we're all part of that. So we get to have a voice in that now. And so that's the question. Is it more in the public good to ban abortions, or is it more in the public good to keep the options open? That's the question. The question of what's the majority opinion to me is irrelevant for what the state should do.
Professor Soohoo, do you want to add anything to that?
Yeah, I mean, I think, you know, I've learned so much actually, so I'm really happy to have been part of this. You know, I think also one thing just to keep in mind, right, that other religious faiths also have different interpretations of their faith, right? And, you know, Catholics for Choice is very active in terms of protecting abortion rights, and you know, and so I think we just need to keep that in mind for other faiths. There's sort of a range of ways to interpret their faith. And the other thing is, I absolutely agree in terms of, you know, the state should be thinking about what's in the public good, and also not trying to impose, you know, a majority or minority religious view on people. But the other thing, I mean, I think the other crucial thing about the Roe decision was just this idea that people have, you know, this protected liberty around them, right? So regardless of what the state does and doesn't do, there's a limit to how far it can go, right? And I feel like that's sort of the thing that has been lost, right? That we've lost this protection around a pregnant person's body that says the state may adopt a view about the meaning of fetal life and the value of it, but there's, you know, there's a boundary that it can't cross.
And on the point of different schools and other religions, one of the questions from anonymous attendee is asking, what about other religious views? I encourage you to just Google around. There have been articles out there about these kinds of bans would infringe on Jewish religious practice in the country. And then I wrote a piece in the Chronicle about Muslim religious practice. I mean, there's a lawsuit right now coming out of Florida that is actually challenging this on the grounds that it violates Jewish Americans' freedoms. So just do a little bit of very easy Google research and you'll find a little bit about other religious beliefs on this question.
So I think it also raises the broader problem, or what some of us think is a problem, of Christian nationalism, right? In this country, we're taught about the separation of church and state, and we're taught about the Establishment Clause and the Free Exercise Clause. But what we're finding, those of us who are not Christian, or those of us who may be Christian but don't necessarily adhere to the version of Christianity of those who wield power, right, whether as judges or as policymakers, elected officials, et cetera, is that the more we're diversified, or the more diverse we are as a country, the more that stark difference is shown that, wait a minute, these rules are actually based on some foundational values that are quite rooted in a certain interpretation of Christianity, right? As opposed to a complete separation of that, especially when it comes to state lawmaking or policy making. And, you know, one of the reasons why I was so grateful that Professor Quraishi-Landes contributed is because she shows how, for example, among Muslims, it's not a replica. It doesn't mirror it. It would be a very different outcome. if this country was based on, you know, Islamic nationalism or more Islamic principles. And I suspect the same thing if it was if Judaism was the underlying religious national identity. So this is something this is a much bigger issue. Abortion is bringing it to the forefront, but it is a bigger issue in terms of how do you live in a religiously plural society and not have laws that implicitly, and sometimes not so implicitly, are really perpetuating a certain religion or a certain interpretation of a certain religion's view on something. And I think that is inevitable. I mean, we're going to have to deal with that, whether it's with abortion or with something else. Let me skip to another question here, and this somewhat relates to the international.
I was just going to underscore your point. Just if you look at the opinion, they're very careful not to say, we think life begins, right? What they're leaving it to is they leave it to the states. And then smart legislators won't say, Christianity says blah, blah, blah. But I think it's pretty clear that there are, not everybody, but there are politically active Christian nationalist movements who want to use state law to impose their particular beliefs on other people because they believe, maybe they do believe it's in the public good, but they haven't made the case that's convinced the rest of us. They're just motivated by their own particular beliefs. The reason I'm concerned about what the Supreme Court has done, besides just the holding, is that its analysis of our fundamental rights, and this is my constitutional law professor hat, the analysis of fundamental rights specifically says we can only identify implied rights, unenumerated rights, the ones that are not listed in the Constitution specifically, only if they're rooted in tradition and history. And that has been interpreted different ways. So I could say, well, it's rooted in tradition that we have freedom. But if you identify rooted in tradition that we have freedom in 1845, that's a different group of people with freedom than 2022. So when this case, if you look at the opinion, they specifically cite 15th century, 13th century, 17th century, 18th century. It really isn't much more. I think 1940 was the latest date of one of the appendices. So the fact that they're looking to identify what the Constitution believes is enough to interfere with the political processes, which we know can be majority rule and sometimes mob rule. So minorities should be very concerned when this is getting thrown to the states and the majoritarian processes. Set aside our own problems with everyone getting heard in the democratic process. But if this is getting thrown to the states and the court will not interfere in ways it used to interfere when there was a fundamental right, because the only time they'll interfere is if it's something that's rooted in 1865, that is very concerning to anybody who didn't have power in 1865.
Absolutely. Thank you for saying that. And I just wanted to throw out one other thing in terms of just this backward looking critique. It was also cherry picking, because abortion was actually legal, when the nation was founded. It wasn't until like the mid 1800s when abortion states began passing laws making abortion illegal. So I think, and I think Alito doesn't really deal with that fact.
So I'll jump to the question about someone asked the international implications. I'm trying to, just a second. Yes, and Professor Soohoo, maybe you can start with this. It says, do you have an opinion or projection on how the anti-abortion law might affect communities beyond the borders of the US in terms of that USA's decisions tend to have an effect beyond its border?
Yeah, I've been having a lot of conversations with people about this. I mean, I think it will have an impact, but I feel like the other thing I've been hearing is that the Supreme Court has really lost a lot of its prestige. And I think a lot of human rights lawyers and a lot of people who are doing work in other countries have said, high courts aren't really looking to the United States for leadership anymore. That said, I think that there are going to be conservative countries where they're going to, jump onto this decision. Countries like Poland or other places, right, where they want to justify conservative constitutional interpretations and ban abortion. And I think they're going to jump on this decision. The other thing to keep in mind is that really international human rights law has really expanded recognition of that people should have access to abortion, that's a human rights violation for abortion to be criminalized. And there's really, really strong human rights law. There are really strong cases that recently came out of Mexico and Colombia recognizing that people have a right to abortion. So the United States is really going against the international law and the trend in most countries. And hopefully, there's enough there in terms of, again, statements from international human rights bodies and high courts of other countries that are highly respected. But I do think that countries that want to ban abortion rights are going to jump onto this decision.
Professor Quraishi-Landes, do you have any comments on
I would
that?
just say all the more reason to define liberty by looking around today as opposed to looking backwards. Let's look to see how people think about liberty today. If you want to look outside the country, then look at other countries and let's take a temperature. What do we think it means?
Well, to play the devil's advocate, how do you balance minority rights with majoritarian perspectives? So on the one hand, like my last slide, and I remember when I was putting the slide up, I thought, I'm a bit conflicted, because on the one hand, you see that the public supports more than 50%. I think the average is 59% if you don't divide by political party. And among women, it's 67% that support the right to choose an abortion, not the right to mandate an abortion. Everybody can choose. And that's, so if we want courts to establish the legitimacy by at least being in tune with the majority, that's quite persuasive. But then if the courts did that, we would still have segregated schools. We would still have, the right to vote, thankfully, was through constitutional amendment, but we would have all sorts of sexist and racist laws.
But yeah, we got an amendment, but after a war, yes.
And so how do we balance that? How do we balance preserving minority rights, or courts, I should say, preserving minority rights, but also being at least attuned to the evolution, right, of social norms in society, such that you don't have a court that is literally existing as if it's 200 years ago, which is a recipe, in my opinion, for an illegitimate court.
I mean, you're talking about something that I spend many, many, many hours in my constitutional law class talking about, right? I mean, the Supreme Court is not a majoritarian body. It is a counter-majoritarian body. It strikes down majoritarian law. So it doesn't feel very democratic. So what's the role of the court in our system? So there's all kinds of theories about justifying what is their role. One of the justifications is that they step in when minorities' rights are getting trampled all over. And who else is going to do that in a majoritarian democratic system? It has to be somebody who has the ability to be outside of that process and then step in, which is why you have life tenure, so they're not susceptible to, what the next election, that kind of thing. And so there's lots of other theories about what their appropriate role is, but that's one of them, and I think carries a lot of weight. And so then the question is, okay, so when are they stepping in? If it's clearly discrimination against a particular racial or religious minority, then they do step in. There's constitutional text to back them up. But what they've done, at least in this area for about 40, 50 years, is things that are fundamental rights, things that we think of as our fundamental liberties, that individuals, regardless of what the majority thinks, they cannot trample on these fundamental rights of yours. And so we've had a whole series of case law. That's why she mentioned the substantive due process case law that builds on, it starts with the right to teach your children how you want to. There's a question in the chat about privacy. So the Islamic law stuff on abortion has nothing to do. There is a concept of privacy in Islamic law, but the abortion discussion is not from that. The abortion discussion in Islamic law has to do with when life begins. That's it. But in the American constitutional law, the right to access to an abortion comes from a series of cases that start with the concept that we have privacy over our most intimate family life decisions, relationships, starting with how we raise our children, going to choosing not to have children, which is where you get the contraception, to who we marry, regardless of the race of the other person or the gender of the other person. And then you get to the right to choose not to have a child, even if you are pregnant. And that's where you get Roe. So that whole series of cases, none of them are written down in the Constitution. It's a fundamental right that the court has found is implied in the Constitution based on what we understand as our general liberties. So based on that fundamental right, then the court will step in against a majoritarian process to protect individuals whose under the majoritarian vote has lost their access to that fundamental right. What's happened is, in this case, they've rolled back their analysis of what's fundamental to at least 100 years ago, if not more, which again, like I said before, should be concerning to anybody who identifies with a community that didn't have voting power back then. I mean, it's a little ridiculous to look at what was the law of the land in 1860 or 1500 or 1775 when African Americans and women couldn't vote. So who I don't care what the laws were then. It didn't represent what I would have voted for. So that's the problem, is it does step in to protect minorities after discrimination and fundamental rights. But now we're defining fundamental rights very differently than we have for a long time. I don't have an answer for you. That's just my academic pondering.
Yeah, and I would add, I also feel like that was excellent, and that's why I love being around con law scholars, which I am definitely not. But I feel like there's like a lawyer answer, and then there's also an advocate answer, right? In terms of absolutely, the court's job is it's counter majoritarian, right? It's protecting the rights of individuals against state power, right? And that's what it's supposed to be doing. But we also recognize that, in fact, the court, Brown versus Board of Education, right? All of the major Supreme Court decisions recognizing new rights have come out of social movements, right? So it's that pressure often it's that pressure on the court that makes it recognize the rights. So keeping that in mind. And also the last thing I think that's most disturbing about this court is, the first step is they take away the protections, the rights. And then I think the next step is when the majority actually recognizes that people have these rights, the court stepping in and blocking that, right? So I think the new concern is that if Congress actually gets its act together and passes the Women's Health Protection Act, is the court going to look for arguments to strike it down? Right. And I feel like that's been the long-term game of the Republicans, right, in terms of recognizing that the composition of the country has changed. Right. And so, so then we're in a world where they're gerrymandering, right, in terms of keeping that majority in the democratic process. And then they lock down the court so that even when, there's an overwhelming majority of the country that wants something, the court can block it. And I feel like that's where we're moving.
Well, and you also had to add the wrench in the analysis or in the reality of our political system, which is legalized corruption through campaign financing, right, with Citizens United and all this dark money. And it's one thing if we had a relatively more democratic state such that one could confidently say that whoever is elected to office is not a product or a result of corporations and wealthy individuals effectively funding that campaign, as opposed to someone who truly has the popular vote without that intervention. And that, I think, is where the Supreme Court really has its blinders on when it claims that, look, we're not saying that abortion should be prohibited. We're simply saying that this is a legislative matter. This is essentially something that the states in their legislature should decide, or Congress should decide. And this is just really none of our business, and almost a separation of powers argument. Mm-hmm. I mean, and separate from the fundamental right privacy doctrine. So I disagree with their analysis. But even if you were to accept that arguendo, they're completely disregarding the problems with our political system. And it's one thing if the outcome of those problems affects, your property taxes or affects traffic laws, but when it's affecting your bodily autonomy, it's something that warrants kind of weighing on the side of, yes, this is actually more of a fundamental right. And even if we have some issues with the jurisprudence, it doesn't matter. There's too much at stake here. And clearly they're not willing to be that purist when it comes to other rights like gun rights or interpretations of more traditional libertarian values. So there's a lot of contradictions in their reasoning.
Yeah, there's one of my favorite quotes from a Supreme Court case is arrogance cloaked as humility. Like it's a little rich for the same court that many people feel has made it very hard for our democratic voice to be heard, to then say, oh, you decide, you people, you decide, popular sovereignty. And yet popular sovereignty has been tweaked and crunched and limited and controlled by people who really isn't the people. It's a little frustrating to hear like, oh, it's not us, it's you. And it's really you, them.
So one other question I have, and then I'm going to turn to the questions that ask, what do we do from here? And we'll spend maybe the last 5 or 10 minutes trying to motivate the audience to stay positive and stay optimistic. But one of the confounding aspects of the opinion was how the Alito was focusing on potential life, right? This is what makes abortion different. So don't worry, all of you who are reading our opinion, to our majority opinion, to think that this is just the opening of the floodgates to reverse all sorts of other cases regarding school segregation, regarding contraception, regarding all sorts of other things, and same-sex marriage, etc., or even anti-miscegenation laws, because this is different. This is about potential life. These other decisions don't affect potential life. And then he goes into this diatribe about the flaws with the viability analysis and critiques Casey. And this is where I think it becomes obvious that this is about religion to me. Because in some ways, the viability argument is one that says, look, we're just going to rely on the science. Right? We're going to look, the science can show it. And they accept that, yes, technology changes, such as now a fetus is viable outside the womb at 24 weeks, whereas 10, 15 years ago, it was really 30, 32 weeks because they have these NICU services, et cetera. But to me, that sounds like, okay, well, so we'll just follow the science but when you're not even willing to follow the science to determine potential life, meaning that the life can live outside the body of the woman, right? This is now a separate life, right? In terms of scientifically speaking, then what you're really talking about is religion. You're kind of going back to, no, this is really about religion, but we're not going to say it's about religion, even though we keep saying profound moral issues, which implies religion. So I'm curious to know what you all thought about kind of that component of the viability argument or the critique of the viability, and whether that is, is that something that could be an advocacy strategy in the states that might be on the cusp where they may or may not prohibit abortion? And so those who are being pragmatic will say, okay, let's just get a law passed that focuses on viability, and then we can kind of put the threshold at 24 weeks, and in at least percentage wise, the number of women who will be denied the right to access abortion will at least be smaller, even though I realize it doesn't address the bodily autonomy principle to its fullest extent.
Well, I feel like there was a lot there, and I really I thought that was a really good summary of like a lot of the problems. There's been a lot of critique about the viability line, and I think the strongest argument for it, I think you've already articulated, is really that it's scientific fact. Right. I think that when we sort of let the states adopt one view or another, it's not going to be based on fact. Right. And so the religious people's views about the moral status of the fetus are going to be part of whatever choice people make if it's not viability. In terms of also, I think that you're absolutely right that Alito says he's not adopting any view, but right, he's talking about abortion and trying to distinguish it because it's a moral choice, right? It's only a moral choice if you have a certain view about the fetus. I think later in that viability discussion, he argues that it's unfair because the state can't act to protect the human rights of the fetus, right? So that assumes, right, that the fetus has human rights. So I feel like I just want to underscore that. And then the other thing, I think you started talking about the threats to contraception and other things, right? Already we're seeing, I think in Missouri has a total ban on abortion. And I think hospitals have said they're not going to distribute Plan B anymore, right? So emergency contraception, because again, based on an interpretation that an abortifacient prohibits the implementation of a fertilized egg, right? So already we're sort of seeing religious interpretations cloud, the meaning of what's an abortion. So I feel like that's problematic as well.
Also, certain forms like in vitro fertilization sometimes involves discarding fertilized eggs. And so I think you're going to see legislation attempts at anything that involves any kind of fertilization of an egg fertilized, anything like that. That seems to be where the focus is. That's where there was space in this opinion that you can make legislation, because they said that's abortion is separate. It has to do with potential life. So anything having to do with potential life, that's where you're going to see legislation. Unfortunately, I think, because I think there's probably already an effort to identify unborn. I mean, they even changed the language, like unborn human being, I think is in the opinion. So try to establish a fetus as a person within the constitutional rights of personhood, right? So then you end up with serious clashing with people. Like I said, many Muslims believe that's not a life before 120 days. And so, I mean, as far as what to do, I mean, I know it's really a very dark moment, and it's been very hard for anybody who feels very strongly about that this is going to be bad for a lot of people. I would like to turn the religion argument on its head, which I think some of these cases are doing. So if in fact this is motivated by religion, and if in fact we're serious about religious diversity in this country, which our free exercise clause does say we are, then I hope that we can all get on board that at the very least, we can, whatever laws are passed will not infringe on people's religious practice. And if you do that, and you take Islam and Judaism seriously, you're going to have to accommodate for abortion at least the first 4 months, and for the life of the mother the whole time. Now, that's not viability. That's a whole different range of conversation. But I think if you're thinking about harm on the ground today, I would hope that at least we can all agree that we don't want to have a law that infringes people's religious freedom to that extent. And I think Muslims should get on board with something like that, you know, we agree that you can choose which school to follow. And so therefore the state should still, a secular state should also give you that. A secular state that believes in religious liberty should give you that freedom. Now, the counter argument to that is, well, you don't have to have an abortion, although in some cases, Judaism says in some cases of life of the mother, you have to. So therefore, it's not really infringing on religious freedom because you're not obligated to do it, like you're obligated to fast or something. But I think that's a little bit of a thin argument, because we want religious freedom to do lots of things that aren't mandatory in our religion. I would like to do a few extra prayers, maybe. I don't want the state to prohibit me from doing that because I don't have to do those prayers, right? So I think the idea of religious diversity and the life of a diverse country is that whenever possible, we try to enhance people's spiritual path, whatever they choose, and we only infringe on it when there's really a strong case that this is the only way to serve the public good. And I don't think that case can be made here.
Although the other counter is that what about Christians who believe that, well, they would have to make the case that they also believe their interpretation of Christianity allows abortion. And then you have atheists or you have other religions who maybe don't have any particular view, but yes, the
strong counter is if you really believe it's murder, that's a strong counter. But my counter to the counter is, yeah, but there's other religions that believe killing a cow is killing essentially a human life. They don't believe in killing animals. So if we're just leaving it up to everybody's interpretation of what's a life based on their spiritual understanding, there isn't really room to have a functioning diverse society. You just can't, it doesn't work that way. You have to have a different calculation for why we make laws for everybody.
Which is why science matters.
Science would be good, but apparently we're not on board with the science. So at the very, on the loving thing, on the racial, so Justice Thomas specifically said it's beyond just the abortion cases. He would actually go beyond just things having to do with fertilized eggs, and he would open up all the substantive due process case law, which would go all the way to questioning same-sex marriage and all the way down. Now, he specifically doesn't mention interracial marriage. I wonder why. And so therefore, he says that's not on the table. But I think if there's any more votes with Clarence Thomas, everything's on the table.
So we have a few minutes left. We're going to end at 2:30, but in these last few minutes, I'd like to get, maybe each one of us can tell, particularly the younger generation that's going to be experiencing the burden of this, the consequences of this decision for decades. What do you advise for law students, advocates, engaged citizens who disagree with the Dobbs decision and believe that abortion should be accessible to all women who want to have one?
Yeah, maybe I'll start. I mean, I think, I don't know how many lawyers are out there, or law students. I feel like there are, we're like in the woods, right? And I think we're sort of in a position where we need to be rethinking the arguments that we're making and developing new arguments. I feel like making arguments based on the Establishment Clause and freedom of religion are really exciting, especially because, we have a Supreme Court that says that it really is in favor of religious rights, but really it's only the religious rights of a certain group. So I feel like that's also helpful just in terms of trying to turn that jurisprudence around. I think there are interesting arguments to be made relating to women's equality and non-discrimination. I think there are arguments that could be made under the 13th Amendment. I think we should be thinking about developing these arguments for a time, when the Biden appointees maybe are more numerous on the federal courts, so that we need to be making arguments in state court. I think the other thing that we need to do is recognize in the short term, like, what can we do to make sure that people have access, right? There's going to be just so much suffering out there. I think people should be contributing to abortion funds and making sure that people have practical support. I think that we're going to see a lot of people, both people who provide abortions and people who have them, who are going to be criminalized, right? So I think there are lots of resources. There's If, When, How has a bail fund for people, right? So I think we should be thinking about how do we provide legal defenses for people once they're prosecuted. How do we make sure that people have information in terms of how to safely end their pregnancies on their own, right? Because a lot of people are going to be turning to medication abortion or other methods. So we need to make sure that they have safe access to pills. So I think these are the kinds of things we should be thinking about in the short term.
Those are all really helpful, practical suggestions. I guess the one thing I would add is again, because I'm coming in this from a Muslim, Islamic law and Muslim community perspective, there's lots of other things I could say about the legal stuff, but that's been covered really nicely. So I'll add this, that I think it would be really a service to the future of Muslims in this country if Muslims could be known as putting the greater good first and not just what I believe for myself. And if we could project ourselves with that perspective. So I invite Muslims to, if you're inclined to agree that abortion bans are bad, but you're not quite on board with the entire full-throated abortion on demand at any time, and you're worried that you might be associated with that kind of perspective, and so therefore you're not going to really be on the ground for this, I fear that the harm that you might be complicit in is a harm that we shouldn't be known as assisting. We should be known as standing against that kind of harm. And Muslims in America, we've been here since before there was an America, United States, and we're here now in numbers that I think people are paying attention to us. And instead of us being known as, oh, Muslims want to take over the law of the land with their Sharia, I think we should be known for, when Muslims come here, when Muslims are here, not just come here, but Muslims are part of society and public discourse, we want to help. We want to help everybody. And if we can send that message in this moment right now, I would really, I think that would be a huge service to countering some of the Islamophobia that we all experience.
Well, you all made a lot of the points I wanted to make, but I will just succinctly say that it's time for a revolution. I think that this is a wake-up call for those of us who have been kind of comfortably relying on a system or a set of laws that we agree with and not appreciating that they can be taken away. And thankfully, we do have a young generation that is very woke. And now it's about taking that wokeness and translating it into power and into action and not just talking. Obviously, this lecture is just talking, but we have to figure out a way to translate that. I think the most single important thing we can all do at an individual level, which will not create massive change immediately, but it will create massive change over time, which is that we all have to get politically engaged. There's just what we witnessed with Dobbs, where a 5-decade-old case of stare decisis in a common law system where precedent is like the most powerful source of jurisprudence, has just been nakedly and unabashedly overturned, means that, I mean, it's an invitation for us to be politically radical. And so we've got to, I can give you all kinds of lists from you got to contact your Congress people, not because they're necessarily going to listen to what you say, but because they actually pay attention to the number of people who email them. They pay attention to which telephone number or zip code. They pay attention to who's voting. So it's not about your one voice making this major difference. It's about all of our voices. And if the other side, which clearly has been doing this to their credit for 20, 30 years, has been loud and has been active and has been funding campaigns and advocacy, then it's time to compete, right? It's time to compete. And part of the civic engagement and the political engagement has to be tied to the legalized corruption in our society. It will be very difficult for any majority viewpoint to ever be represented as long as the wealthy individuals and corporations essentially pick our elected officials. And the system is rigged, it's legalized. It's not even, that's why I call it legalized corruption. If it was happening in any other country, we would be having all kinds of reports about it. But here it's done. So you've got to understand Citizens United. You've got to understand the gerrymandering laws as part of whatever substantive policy issue that you care about or civil rights issue that you care about. And I know that's a heavy lift, but the stakes are high, right? Because if you're a woman who wants an abortion and now can't get it, you have to figure out how you're going to raise this child, how you're going to get daycare, how you're going to feed the child, how you're going to work, how you're going to go to college if you want to go to college, how you're going to have a career if you want to have a career. I mean, it's devastating. It's devastating, all of the burdens, the economic and social burdens that are on you if you don't get to just make that choice for yourself. So I think that it's absolutely worth the fight, and we have to do it. So with that, I hope that you're motivated. And there's lots of work to do. And so I look forward to engaging with all of you and continuing. Both Professor Quraishi-Landes and Professor Soohoo, thank you so much for your expertise. Thank you to everyone who is online. We had up to 130 people listening and hundreds more who registered. And if you want to stay engaged, follow the Center for Security, Race and Rights, csr.rutgers.edu. We have many, many more good trouble work that we'll be doing. And yeah, in solidarity. Assalamu alaikum.
Assalamu alaikum. Thank you for organizing.
Thank you.
Bye-bye, everybody.